Fifth Circuit Radicalism. No right to bond for DHS detainees. This is Law and Society. Please subscribe. We're going to talk today about the Fifth Circuit decision in Buenrostro Mendez and Covarrubias v. Bondi and Nome. So the case is about getting bond, about getting being able to post bond, post bail, and leave, be allowed to leave the incarceration during the pendency of the case. In this case, their removal proceedings. And so the case turns on these two people who have been in the United States for a long time. They have relatives who are U.S. citizens in the United States. And the question is whether they are in a different place statutorily than the people who are coming through the ports of entry and are seeking admission. So the statutory interpretation of applicant for admission versus seeking admission. And the majority of the federal Fifth Circuit Court of Appeals, the two judges pretty much said that, an applicant for admission is seeking admission, and therefore those two mean the same thing, that requires mandatory detention during the pendency of their immigration status or their removal process. Now, there's also, so essentially the Fifth Circuit said that you can hold, because one of the statutes of people seeking admission, because they come to the ports of entry, they can be held mandatorily detained until they are allowed into the United States or denied entry, versus people who have been here for quite a while. They came in when they were undocumented, and now they have families and lives in the United States. They are both, those both categories, whether they were first apprehended at the port of entry where they were seeking admission, or whether they are already in the United States and immigration and enforcement has just apprehended them years after they've been in the United States, who have no criminal records, as applicants for admission. And they are both the same things, and therefore the federal government can mandatorily detain them and deny them bond. And that's what the Fifth Circuit held. Three judges. And at the end of the ruling, at the end of their majority ruling, the court says Department of Justice Inspector General found in 1997 that when aliens are released from custody, nearly 90% abscond and are not removed from the United States. That situation exists today on a much larger scale. The petitioner's fears about potential abuse of detention pending removal proceedings are wholly speculative. Mind you, there are two things here, and the idea that these people who have been in the United States and who are not just entering and being apprehended by ICE, but have been here and have lives in the United States and families, they don't fall into the category of people who abscond and are not removed simply because they have settled lives in the United States. They can't just pick up and leave and disappear. And also, the petitioner's fear about potential abuse of detention, if you see what is happening in the detention facilities that people are suing about, then you no longer can call the abuse of detention wholly speculative. But this court says so. In any event, U.S. Supreme Court precedent has no direct application to aliens who are detained and being given due process during removal proceedings. And we know that they're not being given due process during removal proceedings. That's one of the problems. They are being detained, denied their right to counsel, and the fact that people are now by the thousands suing and bringing habeas petitions against the government is because activists and people outside have been pushing the government to allow the right to counsel for these people who have been detained. And so the dissent says applicant for admission and seeking admission are two different statutes, and Congress did not create one statute and then another statute after that and keep them both separate in order for them to mean the same thing. Whatever precisely seeking means, this difference in part of speech indicates that seeking admission is something different than being an applicant. The dissent says, in sum, the government's proposed reading of the statute would mean that for the purposes of immigration detention, the border is now everywhere. That is not the law Congress passed, and if it had, it would have spoken much more clearly. So that is what the case is about. I came to know about the case because I was looking at so much other information coming out. I came to know about it from, obviously, Dr. Heather Cox Richardson, and then I looked at Steve Vladek's Substack, and he wrote about this quite explicitly, and he quotes Aaron Reichlin Melnick to say that the Fifth Circuit's decision will fuel ICE's push to transfer people to Texas immediately, and will put even more pressure on plaintiffs and district courts outside of the Fifth Circuit. Unless the habeas is filed before the person is transferred to the Fifth Circuit, a person may remain locked in appalling conditions, never even allowed to ask for bond. All of that can be traced to another procedure of technicality, the principle that a district court gains jurisdiction over a habeas petition only if it is filed while the petitioner is physically in the court's jurisdiction. In other words, to avoid being subject to the Fifth Circuit's decision, which, while it remains on the books, detainees arrested elsewhere would have to have someone file on their behalf before they're physically transferred to the Fifth Circuit. And, it creates this discrepancy where there are thousands of district court judges who are saying that, no, there is a right to get a bond hearing, and the Fifth Circuit is saying, no, you don't have that right to get a bond hearing. Vladek says the precedential effects of the panel opinion in other cases are immediate and will persist until and unless that ruling is vacated by a grant of rehearing en banc or vacated or reversed by the Supreme Court. So it's important for the legal proceedings to move forward for the two plaintiffs in the district court case who are seeking their habeas corpus rights, and they were granted by the district court. They need to quickly appeal this ruling, and Steve Vladek recommends that you go directly to the Supreme Court, or you go to the en banc of the Fifth Circuit. It's difficult to tell which is more conservative leaning, or which of them would interpret these statutes to mean the same thing or something different. What I thought about, which is, I guess, it's part of the discussion, is that the Eighth Amendment says excessive bail shall not be required. While the Eighth Amendment does not prohibit the federal government or the court from imposing, not allowing bail at all. It's not that denial of bail is unconstitutional. But in a case where it is a habeas petition coming off and the person has no criminal history, has been in the United States for quite a while, they are applicants for admission if they are in immigration proceeding, there's no chance of a flight risk or absconding because they are established people with families and identities that are localized and made permanent. They don't fall into the category of them being flight risks or risks to the public. Because even though courts can deny bail based on the flight risk or risk to the public, those instances don't exist in this case. The appellate court seems to say that absconding and avoiding removal is a problem for the government. It justifies refusing bail altogether. Evidently, although there is no showing that petitioners would in fact abscond or have done so before. In a sweeping order, the Fifth Circuit denies bail to all detainees held by immigration officials, and it kind of goes against what Supreme Court says in saying that these habeas petitions need to be taken up on an individual basis. A national injunction won't work. So yeah, they're taking these petitions up on an individual basis. If SCOTUS said that there's no right for you to be released, thereby getting your right against detention, they acknowledge that. If there's no chance of that, if you are going to be denied bail bond during the pendency of your proceedings, then why would the Supreme Court allow you to or suggest that individual habeas claims be brought? That it doesn't make sense. And so the Eighth Amendment question, I think, if you say somebody is denied bail, you do that because of their flight risk or a risk to the public, and none of those are existent, and you still deny somebody bail. Denial is as high as excessive bail can be. You're being denied it completely, absent showing of the requirements of being flight risks or risks to the public. And I think that this is kind of a borderline case about statutory interpretation, so it's hard to tell what the Supreme Court will do, but it makes no sense for the Supreme Court to first say that you have to bring habeas claims individually and then say that those habeas claims really don't mean anything because, you're not going to be let out of detention. And that is essentially what is going to be the argument. And then why did the Supreme Court want the habeas petitions to be filed individually to begin with? So with that said, I hope I've not confused you about this. It's important that we know about it. Let's see where the case goes. And we're going to see if people who have established lives in America are given the right to apply for admission and be able to leave their incarceration pending their proceedings. Thank you for listening, and I'll talk to you soon.